Hello, everyone, and welcome back to the Jurisprudence podcast with me, Alex.
And me, Charlotte.
And Charlotte, what are we talking about today?
So, we're gonna do a little deep dive into the history of the English trial.
Okay. Now, my first question is because this is the thing that you've been doing
Yeah.
all the last couple of weeks, this is your first one. What is the reasoning for doing a history of the English trial? What's the why behind this?
Um, well, first of all, I wanted to be a bit self-indulgent and talk about the criminal trial
Well, that's fine.
because,
Yep.
um, also the sort of influence for me doing this comes from someone that I've been reading quite a lot in my PhD, Anthony Duff.
Okay.
And that also brings me into the second reason that him and a few other criminal theorists, scholars in the field, did a trilogy of books doing a deep dive into the history of well, not just the history, but the criminal trial itself.
Yes.
Um, and the kind of principles that influence it, that make us value it so much in terms of what it means for justice and why we centralize it within the criminal justice system. So, in the third book, they do a similar thing that I wanted to do today, which is to do a historical account of how the trial came to be. And that was really justified by this idea that things that we have, um institutions like the government
Yes.
and the trial
Yep.
and police
Mm-hmm.
and things like that, we sort of take them for granted and assume that they've always been there and they've always served the same purpose and they've always been supported by the same kind of ideals. And uh they look back into the history of the criminal trial in England and Wales and kind of basically in search of the foundations of these principles that we've imbued into the criminal trial, and sort of brought to attention that these have developed over time as we've seen um, the function of the trial
Yes.
develop as well.
So, yeah, that's a
Does that answer your
that
question?
does answer my question exactly. So there is this growing this idea, this perception that, especially because as people who've lived in England and Wales, you grow up hearing about the idea of the trial in sort of common parlance and
Mm.
and sort of colloquial understanding.
Well, we get called to jury
Exactly, we do. Yeah, we
service.
do jury service and all this kind of stuff, and it's sort of like a thing that is, like you said, imbued not just in terms of the legal system, but it's sort of imbued in the culture
Mm-hmm.
of English society, and people would be quite surprised how recent the adversarial trial actually is in
Yeah.
terms of its development. Given
Yeah.
now how long the history of England has been, the adversarial trial is relatively recent. Now, my next question then is, if we're going to be doing a history of the English trial,
Yeah.
we're going to be doing specifically a history of the adversarial trial.
Yes.
What is the adversarial trial? What do we mean when we say the adversarial trial?
So this will come out a little bit more as we talk about the history,
Mm-hmm.
because I wanted to point out this distinction as well, as we go further back. The adversarial trial is um named as such because it highlights a difference in legal tradition. So here we have an adversarial trial, and on the continent in Europe, they have the inquisitorial trial.
Okay.
And the difference between the two, broadly speaking, is the kind of it the way that the trial is structured. So on the continent, you have a judge that basically the process of investigation is imbued into the trial. So over here we have the police that conduct the investigation,
Mm-hmm.
and then they charge the
Yep.
the defendant, and then that goes to trial, and the evidence on both sides is weighed up.
Yes.
On the continent, the investigation and trial process is sort of merged.
Yes.
And then you bring all of the evidence together into one, they call it a dossier, and the one judge, and sometimes in the presence of a jury, sometimes not. It's not as central as it is here.
Okay.
The one judge will adjudicate on law and fact.
That's a very interesting point. That one of the things that you will learn, one of the first things that you will learn in doing either criminal law or criminal evidence in England and Wales is that there is this distinction between law and fact, in the sense that there are factual burdens that are presented at trial, and then there are legal burdens presented at trial. The judge often, at least traditionally in the adversarial trial, is somebody who is tasked with essentially doing a lot of the legal adjudication.
Yes.
And then the questions of fact are left to the jury.
Yeah.
And it's supposed to be the case that those two don't cross over, but there are some examples where there's a little bit of a crossover point. But the idea here is that the jury of lay people, the jury of individuals who are obviously not trained in legal specialisms or whatever, are going to be the people that are basically just going to determine the facts of a particular case, the factual outcomes, the legal questions, things like the admissibility of evidence, the things like hearsay, all that kind of stuff. The really complicated legal stuff is done by a judge.
Yeah.
So, and that's less the case, you say, in the in the civil law tradition in Europe.
Yeah. So here you'll broadly hear a judge saying, if on this evidence you find that such and such occurred, this means that the legal criteria for such and such offense is satisfied.
Yes.
You must find him guilty.
Yes, exactly.
So that's what the function of a jury direction is. It's directing the interpretation of fact toward satisfying the legal criteria.
Exactly.
And that sort of makes the judge and the jury work in tandem, whereas on the continent it's a little bit different, that it's just the judge that's assessing.
Yeah, and for the most part, yeah.
And I think the main difference, though, is the function of evidence.
Yeah.
Which I also think is quite important as we look into the history a little bit more.
Yeah. Should we start doing that then? Shall we start with the history?
Yes.
And you want to do it in a chronological sense, obviously, because we don't want to confuse people.
Yeah.
And really, the first point of call that you want to talk about is the Roman law, because of course the Romans did invade England.
Here.
They were in England, and so we do have to mention the Romans and Roman law and their traditions, even if they are not as influential as they are on the continent as it is here.
Yes.
It is still particularly important. So, okay, so you mentioned to me before that one of the things that made you want to dive into the Roman law is because Duff doesn't explicitly speak about the Roman law when he talks about the trial.
Yeah, so in Trial on Trial trilogy, they don't go that far back because it's not an investigation into legal history.
No.
But I thought it'd be quite interesting for this episode to briefly touch on the sort of influence of the Romans in Britain.
Yes.
Also because it was quite interesting, and the fact that their influence is still seen today in terms of like the formal language of law.
Of course, yeah.
We still use Latin, for example, and
for most things, really, don't we?
Yeah.
So you say that one of the things that really is a byproduct of the Roman law and Roman traditions is this idea of disputation.
Yes. So this idea of legal questions being oral, so a tradition of orality in developing the law and settling disputes, and this was really a source of the sophistication of law in the Roman period. So they had they had jurists which talked about and sort of ruminated about the law and answering legal questions.
Mm-hmm.
And not a lot was written down at this time, so
No.
there's not the same sort of strict adherence to textual legal principles as there is now.
Mm-hmm.
And arguably in the sort of post-classical Roman period, where they moved more towards a standardized trial-esque procedure,
Mm-hmm.
The it was a transition from the formulary procedure to the cognitio procedure,
Okay.
where they involved a magistrate in the adjudication of cases
Okay, that's interesting.
between individuals. There was a shift towards sort of textualism, and that meant that there was more of a one size fits all approach to law. So there was less of this kind of fluidity and sophistication of legal ideas, and more of a rigid application of law for pragmatic purposes.
Brilliant. Okay, that's interesting. And so, really, then there are some basic principles that we start to see from the Roman law, and then there are some key points throughout the history of the common law, throughout the history of law in England and Wales, that we can start to see how the trial develops.
Yeah.
So while this isn't necessarily a history of law in England, or a history of English law, this is specifically about the trial, there are points at which we see how the trial starts to take shape, especially when it comes to this idea of justice and a conception of justice.
Yeah.
Because the point that we spoke about earlier is that we have this sort of weird conception, and we're going to talk about it more, I reckon, in the conclusion. We have this weird conception that what we've arrived at now is the enlightened process by which law takes place. This is the we are the correct. We are providing a rule of law. We're providing due process. We're providing everything, and it was these barbaric, horrific practices that we've strayed away from.
Yeah.
That essentially is, we've seen the light and we have seen how, but
you're alluding to the ordeal there.
I'm alluding to the trial by ordeal, which we'll get to in a second.
Yeah.
But one of the points you want to make is that in their own weird, fantasistic ways, they are actually presenting what they believed to be a just outcome.
Yeah.
Even if to us it's very barbaric.
Yeah. So
the trial by ordeal.
Yes. So what with a shift then to the Romans left.
Yeah, the Romans leave.
The Romans leave, and this like withdraw from Britain leaves a gap where we kind of need to adjudicate for ourselves and figure out our own customs and stuff.
Exactly.
And I would like to make a little side note that in that there were still quite a lot of Romans in Britain, but they were used for their legal knowledge, and the Germanic tribes were quite happy to have Roman jurists write their texts and stuff, because the Latin was still viewed as the legal,
the law, the language of
the language of law.
Yeah, exactly. And so there's sort of like the Romans sort of leave, and then you have the Angles and the Saxons, and then you have the Vikings. Sorry, they start to appear. We have like the heptarchy that exists with Wessex, Northumbria, and all the others.
Yes.
And then you start to see, through the reigns of Alfred the Great, his son, whose name eludes me, and his son, Ethelstan, the consolidation of England. Edward the Elder, that was his son's name.
Yes.
And so we start to see, firstly, also, we start to see the influence of religion, Christianity. Of course, Christianity begins during the Roman times and is eventually adopted by the Romans, and then spread across all of Europe, and so Christianity starts to take a greater role, not just in England but also in the rest of Europe.
Yes.
And so
it's approached quite differently, as we'll get to in a second.
Yeah.
But that brings us nicely onto the idea of the ordeal, because
the idea of the ordeal and the trial by ordeal.
Yeah. So it is stressed in Trial on Trial that they wanted to talk about the ordeal, not necessarily because it's seen as the birth of the adversarial trial as we know it, but it demonstrates that we have kind of a still a formal approach to assessing the accused.
Yes.
So, as you said before, there's this idea that the ordeal itself is a barbaric practice, which is described as an irrational mode of proof. So it's because it's so. It seems like it doesn't come from rationality.
It seems so as barbaric as it comes from us. Maybe we should explain what the trial by ordeal is to people who don't know. It's essentially a situation where, if we want, we'll get into each of the different stages. If you want, the idea of an accusation and witness, but
explain the ordeal first.
Yeah, the point of the ordeal and why it's called a trial by ordeal is essentially you go through an ordeal.
Yeah, it's horrible.
Go through something that's horrible, and it is seen as God judging your guilt or lack thereof in a particular situation. So these are often commonly described as, and you learn about these when you're younger if you live in England and Wales. So one such example is a hot iron. You have to carry a hot iron in your hand as it starts to burn your hand, and it starts to scald your hand, and it starts to blister, and you have to walk a certain number of steps or something. And the idea here is that they would then bandage the hand up, and then after a week or so, if it has healed, or if it has become infected, that's a sign from God that you are either guilty or not guilty of a particular act. And the idea here is that essentially the clergy or a religious individual would essentially bless the hot iron, such that if this person was innocent, they would not blister and they would not get infected. If they were guilty, then God would reveal that guilt in that way. And then another example is the idea of putting someone in water. If they sink, then it is conceived that they are innocent, because the idea here is that an individual who is guilty is an individual who has sinned, and the water repels sinners.
Yes.
So if you floated, you were being repelled by the holy water, and so therefore you are guilty, and then obviously vice versa. So these are the kind of ordeals that people talk about.
And that might sound familiar if you have ever read about the witch trials.
Yeah, exactly. Witch trials, which had a very similar kind of system.
Yeah. So, it's described in Trial on Trial as a relatively formal judicial procedure, and that's why they kind of point to it, because this idea of distancing ourselves from our past of legal procedure isn't necessarily helpful.
No.
Because you can trace a distinct development of kind of understanding this idea of criminal responsibility, how that translates into law and procedure throughout the ages. So it's not just that people back then were crazy and that they were leaving it up to God because they didn't really have an understanding of what it meant to have a formalized assessment of proof and the understanding evidence and that kind of thing. They were actually trying to construct a formalized procedure for dealing with quite complex issues.
Yeah.
It just doesn't look that way because now we've developed quite a lot, and we've come to imbue the trial with things like human rights and et cetera, and
exactly.
there's like an international context now. But anyway,
there's a few points though of reference though. So there is generally a presumption of guilt, rather than a presumption of innocence in these trials by ordeal.
Yeah. So it starts with the accusation.
Yes.
Where the person aggrieved brings they have to bring a prima facie case against the wrongdoer, meaning that it speaks for itself.
Yes.
Um,
So let's say I've stolen your goat in medieval England.
And you go, well, he lives next door, and my goat's missing.
There you go. There you go.
There you go.
That's a prima facie case against the wrongdoer.
And then you have to have a body of witnesses to establish that. So my other neighbors saw him with a goat.
Carrying a goat. It looks a lot like my goat.
It looks a lot like my goat. So, and then there's also a strong presumption of guilt, like you mentioned earlier. So you've stolen other people's goats in the past.
Yes, I'm a famous goat stealer.
Yeah.
And so therefore, all of these things together come to a conclusion that
you probably done it.
Yeah, so there is enough evidence, or there is enough of a case to allow a court or to allow someone who adjudicates to then determine an ordeal.
Yeah. So then next there should be attempts to settle or mount a defense. So at least you get to speak for yourself and maybe, exchange money and say, let's set this aside, I'll give you money for this supposed missing goat.
Mm-hmm.
Otherwise, then the court determines what the ordeal would be, what the form of proof would be.
Yes, and that's how the ordeal was sort of viewed, isn't it? It was viewed as a form of proving something or something else, essentially. If you had blisters on your hand, if it had got infected, that is proof of your guilt.
Yeah.
Rather than anything else.
In absence of being able to dust for fingerprints.
Exactly.
In the barn.
Yeah.
There would be no other way of gathering evidence, and it's sort of a way of filling this gap of not having any sort of, we don't have CCTV back then or anything like that. There's a gap of evidence that needs to be filled, that is more persuasive than just a bunch of people saying that you did it. So it's trying to settle the my word against yours in some kind of way, and if God can say it, then that's
exactly. And I think
good enough for them.
And I think it's not particularly fair to speak of it as barbaric and how stupid were people back in the day when we did this, because there wasn't DNA, there wasn't CCTV, there wasn't a police force, there wasn't any of this, and there was also a very strong conviction that God existed, and that God was immanent in people's lives, and that God was somebody who would be able to make determinations. So where there is basically a void of evidence, and where there is a void of being able to ever come to a determination on the basis of sort of mortal humans being able to come to a determination about what happened, then of course, with no evidence and a strong belief in God, it would make perfect sense that they would find a way of essentially getting God involved in the process. It's just the methods by which this happens is a little bit barbaric, a little bit definitely questionable.
But then I would also like to heavily emphasize the fact that there's this strong presumption of guilt.
Yes, of course.
Underlines it. So, and this runs throughout the history of the trial, actually, in either the way that the process is done, or the way that evidence is produced or evaluated, or indeed the way that the laws are applied and criteria are met.
Mm-hmm.
So, where there are examples of bad character, so if you are considered a thief, it is more likely that you will have done it, and the mode of proof will then be decided based on your character and your social standing. So it is quite sophisticated, but then there are also very problematic elements.
Yes.
It's not just that every person is put before God in the same way.
No.
Which I would argue now with developing due process, there's more of a rule of law and equal.
Of course there is, yeah.
Yeah.
Definitely.
You would hope so.
You would
anyway.
hope so,
Yeah.
definitely, yeah. And so this brings us nicely to the end of the idea of the trial by ordeal
Yep.
and the beginning of a jury.
Yes.
This takes place surprisingly early. This takes place in 1219.
Yes.
The beginnings of the jury trial. And, well, what do you want to say about the jury trial?
So there was a move away from the ordeal, and this left a gap of being basically filling the gap of a lack of evidence.
Mm-hmm.
And on the continent, they rediscovered the Roman canon.
Yes.
And this is where the inquisitorial trial developed. Unfortunately, back then, there was a heavy emphasis on torture evidence as filling the evidential gap.
Yeah, well, exactly.
So if there was a confession, that was seen as the gold standard of proof.
And I guess it probably was also perceived that every time we do this torture, people tend to confess.
Yes.
So they sort of make one link to the other and conclude that, well, it must be just this system is very useful in getting confessions.
Yeah, exactly.
And not questioning whether or not the confessions are valid or not valid.
Well, yeah, there is a truth-seeking question there. That obviously you want the truth in criminal trial, but it's not necessarily the case that confessions are going to be truthful.
No.
Especially if you're being tortured.
Well, exactly, yeah.
But anyway, in England, the jury trial replaced the trial by ordeal, and we were more inclined towards this. It wasn't necessarily called the adversarial process because this principle of equality of arms wasn't quite imbued into the trial yet.
Which we'll get to.
So,
yeah.
They called it the altercation trial.
Okay, yeah. So the altercation trial is really a period that sort of sits between the sort of 1400s and 1700s, roughly.
Yeah, roughly.
Somewhere around there. And what is the main purposes or the main ideas of the altercation trial system? What are the sort of things that are features of this system?
So I alluded to it being sort of a transitionary hold between the ordeal and the adversary. So we have juries, we have a defense, we have the prosecution, which is a representative of the crown.
Just like it is today.
Just like it is today. And it sort of functioned in a similar way as it did today. But the defense was basically on the back foot the whole time.
Yes.
So the defense didn't have counsel.
Yep.
They couldn't subpoena witnesses, so they couldn't make them come into court.
So they were basically relying on the goodwill of a witness to defend them in the altercation trial.
Yep. So witnesses had to come voluntarily, and they were not allowed to give evidence under oath. So it wasn't seen to be there's still this like presence of God in trial.
Yes.
That the prosecution witnesses give evidence under oath, and they are therefore gold standard truthful, whereas defense witnesses, not only are they representing the case of the defense, which is quite shunned already, but also the fact that they're not giving evidence under oath means that it can't be held to the same standard.
Exactly, yeah. And it's interesting that fundamentally the distinction between these two trials, the altercation and the adversarial trial, isn't necessarily the features, the sort of actual things that are there. There's a jury there in both cases. There's a prosecution, which is represented by the crown, similar to how we have it now. There is a defense. You have a sense of defense, at least a perception of defense, and you have witnesses. So it's very, very similar in terms of the features. But the thing that is different is this thing that you mentioned a second ago, which is this equality of arms.
Yes.
This idea here that even though all the features are there, the balance is massively in the favour of the prosecution, and so it makes you question what the actual purpose of the altercation trial really is, which is more to just say, we basically know you've done it, or we don't care if you've done it or not.
Yeah.
We just want to hear what you say before we go and hang you.
Yeah.
Is essentially the point.
Yeah, so while there are juries, the jury deliberation wasn't private like it is today. They didn't go into a separate room and discuss. They also had to return a unanimous verdict.
Okay.
Which is still roughly the case now.
Yes.
And the sentence would be decided basically on the spot and then proceed, and usually that was hanging.
Yes.
So
they were very quick trials, weren't they?
They were very quick. It was like 20 minutes.
Yeah.
Which is completely different to now, which trials can take upwards of days, weeks.
Days, months.
Yeah.
O.J. Simpson trial took a very long time.
Yeah. So I lost my train of thought.
You lost your train. You were talking about the differences between the two.
Between altercation and adversarial.
Yes.
Yes.
Altercation and
so
adversarial.
the altercation really began this idea of calling to account. So it's not just a mode of proof now, but also this kind of theatrical procedure that we go through in order to hold the accused in front of his peers, be tried by his peers, and see what he has to say for himself.
Exactly.
So it's this idea of calling to account and addressing wrongdoing publicly.
Yeah.
And it was only later that the idea of equality and due process was sort of imbued into that.
So really the main distinction between the altercation and adversarial trial isn't that they introduce new things per se, in terms of we're now introducing a situation where we now have a jury, or that all existed already. The system basically existed already, but the idea was to essentially imbue a sense of balance, or a greater sense of balance between the prosecution and the defense.
Yes.
And as you mentioned earlier to me, that to sort of professionalize the trial, to imbue this idea of an equality of arms.
Yeah.
And so the point that you made earlier was that the idea of an adversary is not just somebody who is opposed to you. It is that they are equally opposed to you.
Exactly. Yeah.
So, and if there wasn't this sense of equality, you wouldn't be called an adversary. You'd be called an enemy, or you know what I mean?
Yeah. Exactly.
So the idea of an adversary is not necessarily just someone who's opposed, but opposed on equal footing. And you mentioned this idea that the distinction then is that there is an equality of arms. That there is a prosecution that has a certain degree of authority, and then there is also a defense that has a certain degree of authority.
Yeah. And
it's not one-sided anymore. Or it's supposed to be not one-sided anymore.
It's becoming more equal anyway.
Exactly, yeah. So when did the adversarial trial begin?
Well, interestingly, I can't find the year, but it roughly the 1800s.
Okay.
So...
And that just goes to speak, by the way, from our point that we made earlier on, the idea that this idea of the trial by jury, or just the idea of the adversarial trial in general, is something that existed from time immemorial, is not actually true. We've had a jury system for quite a long time, since 1219, but the idea of an adversarial trial has only existed in the sort of 1800s.
Yeah.
In the Victorian age, basically.
Well, this development of the trial also came with a period of great legal reform for the criminal law.
Yes.
So we had the police.
Yeah.
Robert Peel did a lot of reform before he introduced the police.
Yeah.
And this really, it was almost like whiplash, like reading about it, because there's this great influx of criminal law reform, which tried to imbue the process with a sense of integrity and justice that we see today.
Exactly.
So it's not just about fulfilling this function of accusing people and calling them to account, but also having a formalized process in doing so, and restricting the strong arm of the law through these more formalized actors and introducing the lawyer into the trial, which is another really important step. And that's really when it shifted from altercation to adversary.
Yeah.
Is when defense were allowed to have counsel.
Yes.
And I think this period is basic because we've talked a lot about how the structure of the trial shifted, but I
Yes.
think it's less so now about how the structure is changing and actors within the trial, but more about the substance and what goes behind the formal procedures now.
Yes.
So now that there's this sort of professionalism and equality of arms, it's also about evidence laws and what evidence is admissible at trial, the kind of reduction of capital punishment.
Yes.
So I mentioned here that the establishment of full defense of by counsel in felony trials and the collapse of the bloody code in the 1830s kind of occurred at the same time. The bloody code, by the way, was basically the institution of capital punishment for basically everything.
Yeah. And it's interesting that it's unfortunate that it will take a major event to happen in Europe for there to be the more modern human rights conceptions to be applied in these jurisdictions. Obviously, you have the Second World War, and then you have the European Convention, and then you have the Universal Declaration, and of things like the Twin Covenants and all these different kinds of things. So it takes a huge thing like that to actually lead to the full final abolition of the death penalty.
Yes, exactly.
in England and Wales. But it's interesting just how many things change in the 1800s.
Yeah, we sort of see like a very slow and gradual transition out of capital punishment and a more a shift towards like a more fair treatment of defense. One thing actually that I forgot to mention was with the advent of the jury, jury nullification was quite important in addressing capital punishment.
Okay.
And that's part of the reason why they got rid of it, because the institution of capital punishment was directly impinging on the ability for the criminal trial to be this truth-seeking procedure.
And just for the audience, what is jury nullification basically?
Basically, based on the evidence that is provided, the jury ought to have found a guilty verdict, and yet they return a not guilty verdict because they feel that it's morally correct to do so.
Exactly. So a situation where even if the person is guilty and the correct therefore sentence would be something like the death penalty, especially back then when everything was the death penalty, but the jury would say, well, they're guilty, but
we don't want them to die.
We don't want them to die, so we're gonna return a jury, a nullified jury, basically.
Yeah. So this also changed the dynamics of the courtroom, in that the jury was now less concerned with the preservation of the defendant and more concerned with actual fact finding. Which is their proper role.
Yeah, their role shouldn't be to have any kind of moral considerations about what happens to the person. It should just be, did the person do this thing according to you?
Yes.
Do you think they did this thing? You need to agree. Do they do it, yes or no?
Based on the evidence presented
based on the evidence and based on the standard that we have explained to you.
Yeah.
What through jury instructions, did this person do this thing?
Yeah. So then there's kind of a transition from the public being concerned in the preservation of the defendant, and that role is now placed in the state and the agents within the criminal justice system. So then our final kind of mold of the trial is an institution where people are accused of wrongdoing and they're placed on an equal footing where they're able to present exculpatory evidence, evidence that they are innocent, and then their accuser is able to present evidence why they're guilty.
Yeah.
And they're then tried by their peers.
Exactly,
and, guilt is determined on that basis.
Yeah, absolutely. And so that's how we basically arrive at where we are today.
Yeah.
And so in sort of wrapping up then, thinking about a sort of conclusion, what would you take from this development in history and this development of the trial? Firstly, it's interesting.
Yeah. Oh, definitely.
And I hope everybody has been interested by this episode. But what else would you say is interesting about the development of the trial and key takeaways that you would think about?
Well, I think the main takeaway was the main influence on this episode, which was I study criminal theory.
Mm-hmm.
And Duff is the main proponent of centralizing the trial as the form and function of the criminal law.
Mm-hmm.
And I don't know if I've done a good job of this, but I wanted to place emphasis on how the trial isn't just about process, but it's also about the substance of the law.
Yeah.
And the substance of the law can really drive how the procedure plays out and the different actors within that process.
Yeah.
So you have an assessment of the accused, and the trial does that, but the law also does that as well, and the way that the law is applied can have an effect on the what am I getting at?
Can have an effect on the outcome.
On the perception of the person within the trial,
the perception of the individual, the accused,
exactly,
how they are viewed.
So it's not just about process, but it's also about the law itself.
Exactly, yeah. I mean, in terms of, I think that I would take away from it is that there is this idea that you mentioned that it is somehow that today today domestic justice is seen as the end goal. It's almost like we've had a teleology of the criminal trial, and it's gone from barbarity to injustice, and we've finally arrived at this end goal of the perfect criminal trial. And the reason why I said international justice is because I would draw on an interview that was done by Jeffrey Nice, who was a prosecutor in the International Criminal Tribunal for the former Yugoslavia, who tried Slobodan Milosevic, and he was asked once that what he would change about the ICTY, and he very much wasn't a big fan of this idea of essentially importing into international justice these conceptions of the basic common law idea of the trial, and because it's often quite slow, or it's often something that has just been imported by the US and the UK as a way of basically putting it on show and sort of imbuing its popularity. And he said that was something that was not good for victims
Yeah.
of these crimes in international law. So there are definitely critiques of this system, critiques that have been levied, and so the idea that this is the perfect system that we have is obviously something that is a bit naive, generally, anyway.
Yeah, that's actually quite interesting that you mention victims in the international stage. At the domestic stage, victims also complain that because they are being represented by the crown, they don't actually get a say in the outcome of their trials either.
Of course, no.
So
they are reduced to that of, at most, a witness.
yeah. So in a way, in order to put people on an equal footing in the adversarial trial, the victim is taken down.
Yeah.
And the defendant is sort of propped up to meet that that footing.
Which doesn't seem to be, at least perceptively, doesn't look right.
Yeah.
But it's interesting that that's how the system tends to work.
I think that it really flows from the investigative procedure, like I mentioned earlier.
Yeah.
So in the international trial, it's more inquisitorial because they have this centralization of evidence, whereas here it's very much a separation of investigation and
yeah, there's no world police
yeah,
and
exactly.
world CPS that does the charging and all these different kinds of things, which is interesting. Absolutely.
Yeah.
Well, I think that nicely wraps things up.
I think it does. Yeah.
Yeah. Anything else you want to say?
I don't think so.
Brilliant. Okay. Well, if you've got any questions and if you've got any suggestions for new episodes, do let us know in the comments down below. I hope everyone's enjoyed this episode and has learned something about the history of the adversarial trial and some of the interesting points that we can make about it. And we'll see everybody in a couple of weeks' time when we talk about another topic in law.
And it'll be your turn.
It will be my turn, exactly. So look forward to that.